How does vesting impact my property deed? Imagine buying a house with someone else and not knowing how your ownership is set up. That confusion can cause big problems later. Vesting is how your ownership of a property is legally written on the deed. It decides who owns what and how they can use or transfer the property. When you sign the deed, you are not just transferring ownership. You are also choosing the legal way your ownership is set up. This choice affects your rights, what happens if you pass away, and how the property can be sold or transferred. For example, if you buy a house with your spouse, you might choose to hold the title as joint tenants, tenants in common, or as community property. Joint tenancy means all owners have equal shares, and if one owner dies, their share automatically goes to the surviving owner. This avoids probate, which can save time and money. But if you want to sell your part or leave it to someone in your will, joint tenancy might not be the best choice. Tenancy in common allows each owner to have a different percentage of the property. Each can sell or transfer their share without needing approval from the others. When an owner dies, their share goes to their heirs, not the other owners. This setup works well for business partners or friends buying together but can cause disagreements if one owner wants to sell and the others do not. Community property is available in some states and applies to married couples. Each spouse owns half of the property. If one spouse dies, the other automatically inherits their half, which helps avoid probate. There is also community property with right of survivorship, which combines the benefits of community property and joint tenancy. It allows the surviving spouse to inherit the deceased spouse's share automatically. Vesting also impacts taxes. For example, community property often gives a step-up in basis for the entire property when one spouse dies. This can reduce capital gains taxes if the property is sold later. With joint tenancy, only the deceased owner's share gets a step-up in basis. A common mistake is not understanding how vesting works before signing the deed. People sometimes think that being listed on the deed means they have full control or that the property will automatically go to a spouse or child. But that is not always true. If you want the property to pass to a specific person or avoid probate, you need to choose the right vesting option. Another mistake is not updating the vesting when your situation changes. Getting married, divorced, or adding new owners means you should update the deed. If you do not, the property might not pass as you want, leading to legal disputes or tax issues. To avoid these problems, always clarify how you want to hold title before signing the deed. If you are unsure, talk to a real estate attorney. Make sure the deed clearly states the vesting option and that everyone understands their rights. If your situation changes, update the deed quickly. In the end, vesting shapes how your property is owned, transferred, and what happens after you pass away. Picking the wrong vesting method or not updating it can cause legal or financial headaches. Knowing your options and seeking professional advice helps you make the right choice and keep your property in line with your wishes.